Good afternoon, everyone. Good morning for Michael, who's joining us from the United States. I would like to welcome everybody who has joined us so far and um, welcome you to this series that is organized by the JNF UK. Um, and we will be hearing today from Professor Michael Fischbach. I will first introduce him briefly and ask him to speak a bit about today's topic. And then we will open for questions and answers about anything that you would like to ask about either the presentation or his experience researching Palestine-Israel. Also, there is the Q&A function that I would like to remind you about. You can drop in at any point your questions that might come up during the conversation or the presentation. We are honored today to have Professor Fischbach with us. Thank you very much for joining us. Michael Fischbach is a professor of history at Rudolph Macon College in Virginia, where he has taught since 1992 after receiving his doctorate in modern Middle Eastern history from Georgetown University. He researches issues relating to land and property ownership in the Middle East, particularly in connection with Israel-Palestine, Jordan, and the Arab-Israeli conflict. Fischbach is author of many renowned publications, including Jewish Property Claims Against Arab Countries, published in 2008, The Peace Process and Palestinian Refugee Claims, Addressing Claims for Property Compensation and Restitution, published in 2006, Records of Disposition, Palestinian Refugee Property and the Arab-Israeli Conflict, published in 2003. He has also researched the Arab-Israeli conflict in relation to Black power advocates in the United States and left-wing white radicals in America during the 1960s and 1970s. He published on the topic two books. One is The Movement of the Movement and the Middle East, How the Arab-Israeli Conflict Divided the American Left in 2019, and also Black Power and Palestine, Transnational Countries of Color, which was published in 2018. Fischbach frequently addressed international conferences, including United Nations gatherings, the media, and also worked as a consultant with many international organizations, including the United Nations Development Program. We're very happy to have you with us, Michael, and I would like to give you the floor to tell us more about land rights and the land right issue in relation to refugees in Palestine. The floor is yours.
Thank you very much, Kholoud, and thank you for everyone who's watching. It's a real pleasure to be with you here today. As Kholoud mentioned, I spent a number of years, particularly in the first decade of the 21st century, researching the question of Palestinian refugee property losses in 1948. That research included the first ever, to my knowledge, and apparently the last ever time that the UN Conciliation Commission for Palestine records, or at least some of them, were made available to me at the UN Secretariat Archives in New York. My research also took me to the United Kingdom, to archives in Jerusalem, Jordan. I've done interviews and produced several works that detail the history of the Palestinian refugee property losses, both land and movable property. I've tried my best to determine, based on a number of estimates, what the scope of that land was and other properties, how much it was worth. And in particular, I focused on a massive project that a UN agency, which technically still exists, called the United Nations Conciliation Commission for Palestine, undertook a massive project in the second half of the 1950s into the early 1960s to try to identify every piece of Arab-owned land, Palestinian, Syrian, anybody who owned land in the territory in Palestine that became Israel. Every person of Arab descent who owned land as of 14 May 1948, and tried to determine how much that land was worth. This massive set of UN records still sits under lock and key in New York, awaiting the day so the progenitors of this project hoped to be able to be used someday in any kind of compensation scheme. Today, what I'd like to do is talk to you a little about the fate of the property left behind by the somewhere around 750,000 Palestinian Arabs who fled or were driven out of their homes in 1948. Efforts over the years, what did Israel do with this property? What were the various legal mechanisms the state of Israel used to confiscate this property? And in particular, to note two major sales of this property. After it had been confiscated, the Israeli government made two sales to the Jewish National Fund in 1949 and 1950. And what happened, how much money was involved, what happened to the property after the JNF acquired it. Secondly, I'd like to mention just a little bit about various estimates over the years from UN agencies, Arab agencies, Israeli government agencies, about how much this land was worth and how much land were we actually talking about. I'll also mention why the question of movable property, household furniture, warehouse stocks, automobiles, farm animals, tools, equipment has proven a much more problematic thing to estimate. And then I'd like to talk just briefly about the questions of compensation, of restitution, of what the difference is between those two terms, and how the overall question of the refugees' property fits in with the question of the right of return. And then I'd particularly like to throw things open for questions from Kholoud, as well as from all of you. So with that in mind, let me first point out that as a result of the Nakba, the catastrophe, 80% of the Palestinian Arabs who used to live in that portion of Palestine that became Israel. Israel ended up being created on 77% of historic Palestine, what the British called Palestine. And within that 77%, 80% of the Arabs who had lived there were gone after the war and the first few years thereafter. There's been a lot of interesting, fascinating history since the 1980s of looking at the question of why the refugees, fled. How many of them were actually expelled? How many fled due to psychological terror, and so on and so forth. I think those are fascinating studies and they're worth being done. I would like to point out, though, that the Provisional Israeli Cabinet decided on 16 June 1948 that for whatever reason the refugees were gone, they would not be allowed to return. So in some ways, I think the question that often you find in the propaganda wars, but well, why did the refugees really leave? In some ways, misses the point, which is that the state of Israel does need to own up to the fact that it decided very early in June 1948 they would not be returning. And so the question of their property immediately became an issue. And in fact, even prior to the declaration of the state on 14 May 1948, Haganah and other agencies began willy-nilly laying hands on the land and other property that refugees left behind. But after the declaration of Israeli statehood on the 14th of May, a series of laws and bodies were established formally, according to, again, new Israeli laws, in order to deal with this massive amount, this huge windfall that had befallen the new state. As early as the 21st of June 1948, the Abandoned Property Ordinance was enacted, which created a custodian of abandoned property, and that agency was to lay claim to property left behind by refugees. The emergency, or I should say there was even wider areas, such as the Abandoned Areas Ordinance of 24 June 1948, which gave the state control over abandoned areas en toto, not just control of the land, but anything on it. But certainly in December, on 2 December 1948, a very important law was established as the fighting was winding down, and that was the emergency regulations, the Absentees Property Law, which the important thing there is that it shifted the category of what was going to be confiscated from property to a person, that an absentee could have his or her property confiscated. So it shifted the burden of, in a sense, the object of confiscation from actual property to anything owned by a person, and changed the name of the custodian of abandoned property, therefore, to the custodian of absentee property. I think many people are familiar with the famous absentee property law of 1950, 11 March 1950, which essentially just was a restatement of the law that I just mentioned. But what's significant about this law is that it allowed the custodian of absentee property, that is the state, to be able to sell this land, not just seize hold of legal title, but actually sell it to a so-called development agency. And I'll come back to that when we talk about sales to the JNF. How much land are we talking about? It depends. I mean, land, people say, I can touch it. Surely we know how much was lost. But property is a construct. Property is not a thing, it's a construct. It's a way of looking at things. So for instance, is that land outside the village, which Palestinians call the wa'ariyah, for instance, where we let our animals graze, is that considered the property of the village? Is it considered a property of any individual? Is it considered property at all? Or is it just wasteland? Certainly, historically, Israeli estimates over how much refugee land was confiscated tend to be lower. Palestinian estimates tend to be higher because they include communal land, land generally associated with village ownership, whereas Israeli estimates tend to focus only on what individual persons owned. Because indeed, as early as 1949, Israel pledged to pay compensation to the refugees for their lost property. And as early as 1948, an Israeli commission determined that by the end of 1948, 2 million dunams, a dunam being, there are about 4 dunams to an English acre. Okay, 2 million dunams, 500,000 acres had been confiscated, worth over 328 million US dollars at that time, 1948 dollars. The Ministry of Agriculture the following year estimated that it controlled over 16.5 million dunams. So you can see again, even the Israelis had this huge difference between what they were including as abandoned land. The Ministry of Foreign Affairs in 1953 estimated that it was 3.6 million dunams. The custodian of absentee property the following year, 1954, estimated that that office controlled 4.4 million dunams. And the Israeli Ministry of Justice in 1963, without citing the scope of the land that had been confiscated, estimated that its value was somewhere over 564 million US dollars. Arab estimates, as I said, tend to be higher. The Arab League in 1956 estimated that somewhere around 5.4 billion US dollars worth of land had been confiscated. I think 2 of the most thorough studies were non-governmental, one carried out by a Palestinian economist, Palestinian-Syrian economist named Yusuf Sayer, who in 1966 estimated that 6,600,000 dunams worth 1.6 billion US dollars had been left behind. And then in 1988, a Palestinian named Sami Hadawi and a Lebanese economist Atif Kubrisi estimated that 19 million dunams had been transferred to the Israeli government, worth 2.1 billion. As I mentioned, though, in some ways, one of the, for better words, a gold standard in terms of this question of refugee property was the UN CCP, the Conciliation Commission, which, as I said, carried out a massive study based on British records that were turned over to it in the 1950s and early 1960s. And the UN CCP finally determined in 1964 that 6 million, just over 6 million dunams of land that it could identify had been confiscated, worth 825 million US dollars, 1948 dollars. However, the UNCCP freely admitted it could not identify every piece of Arab-owned property, but those were the amount of refugees left. Movable property was a different matter. Israel stated categorically from the beginning it would not pay compensation for household furniture, for farm animals, automobiles, warehouse stocks, factory goods, anything such as that. And there have been various estimates. The lowest I've seen is $70 million worth. The highest I've seen is 453 million US dollars for the value of movable things. The point is that the new state had this massive windfall of property. It had property on its hands. It needed money. It needed places to settle new immigrants, which were flowing into the country. And this is where the Jewish National Fund comes in. As many in the audience know, the JNF was registered in 1907 as a British company. And in fact, on as early as 13 May of 1948, the Israeli leader, David Ben-Gurion, had offered to sell 2 million dunams of land to the JNF. The JNF refused because Ben-Gurion didn't have control over that much land at that point. In July of 1948, the JNF circulated an internal document talking about a proposal to buy what was called surplus land. That even if the refugees come back, they really don't farm efficiently enough. They really don't need that much land, and that the surplus land could be acquired. But again, that plan never materialized. What did happen is that the JNF very clearly wanted to buy land. And it wanted it not only to be able to settle new Jewish immigrants, but so that it would become, in Zionist parlance, national land, kaka haleom. Meaning that if the state controlled the land and the state had both Jewish and Arab citizens, which the new state of Israel did, 120,000 Palestinians stayed in what became Israel, there were fear in Zionist circles that might oblige the state to distribute this new state property that had been confiscated equally among Jewish and Arab citizens. And in fact, in 1951, an official at a Jewish National Fund Congress said as much when he said, and I'm quoting here, "The fund will redeem the lands and will turn them over to the Jewish people, to the people and not the state, which in the current composition of population cannot be an adequate guarantor of Jewish ownership." The fund, as many of you know, had restrictive covenants that the land could never be sold. It would be held in behalf of the Jewish people in perpetuity, and that anyone renting or leasing property must be Jewish and must pledge only to work the land with Jewish labor. So in order to guarantee that this new land could not be distributed somehow, either to returning refugees or the Palestinians who fled, the JNF was anxious to buy land, and in fact began doing so willy-nilly. But Ben-Gurion told the JNF in December of 1948 not to do that. They would sell it directly. And two great sales took place. In early January of 1949, in fact, 27 January, the JNF and the state reached a deal where the JNF would buy about 1 million dunams of confiscated refugee land for the sum of 11 million Israeli pounds at that time. Eventually, the two sides agreed to a second sale, again, of about another million dunams. Where did the JNF get the money to buy this land? Certainly from loans, including from American banks, the Bank of America, and from donations. In fact, in 1948, 2,047,000 British pounds were raised from British Jews alone to facilitate the JNF in its land purchases. Thereafter, the land was used for a variety of purposes. By 1956, in fact, 68% of all land in Israel that the JNF owned consisted of confiscated refugee property from those two sales. And by the mid-50s, of the 698 Jewish agricultural settlements that had been built on JNF land, a full 577 of them had been built on refugee property. And the British registered JNF, which was still the legal owner of this new property, transferred all its assets inside Israel to a new Israeli JNF or KKL that was established in May of 1954. Let me briefly just say, before turning it over to questions, that the question has always arisen about compensation and restitution. Israel promised to pay compensation for certain types, just certain types, of abandoned refugee property. But it wouldn't pay for the others, wouldn't pay for communal property, it wouldn't pay anything for movable property. Compensation just means we have taken it, we will pay you for it. Restitution is a different legal term. Restitution means to give back the legal title. And Israel categorically from the beginning said it would not do that. It will not return the property to refugees. It would just pay them for it. Now, of course, all of this gets mixed up with the question of the right of return. And one reason why there's no compensation ever been paid in large scale over the decades is that from the beginning, I think really all sides, the Arab states, Israel, and lately the Palestinian negotiators, have recognized that the issue of the right of return and property compensation or restitution are integrally linked. I will say that an interesting question that has to be dealt with is that any compensation for Palestinian refugees will have to take account of the fact that most refugees did not actually own land. An internal UNCCP study, for instance, done in 1965, determined that probably only of the refugees that were registered with UNRWA, that only 39.6% of them had owned land in Palestine, meaning that any larger question of compensation for refugees has to account for the fact that only 40% of the refugees even owned land at all. And some of those, of course, were very wealthy individuals. One interesting thing, though, about the question of restitution is that regardless of the right of return, Israel has always said it will never restitute property back. Because in theory, you could have a refugee that, say, owned land in Haifa or in Jaffa who says, I don't intend to come back. I don't want to exercise a right of return, but I want legal ownership of that land transferred back to me. And I'll rent it to whoever is Jewish living there, but I want it back to me. So restitution and compensation do not have to involve right of return. And in fact, an interesting example of that came in the 1990s when it was discovered that the JNF and some other Israeli banks and other agencies, but the JNF in particular, was sitting on top of real estate, some of it very valuable real estate that had been owned by Jews murdered in the Holocaust. That after the war, after the Second World War, the new state of Israel essentially passed the usufructure, the use of this property to the JNF, and there was a huge scandal that in the midst of people scouring European banks in Switzerland and elsewhere for Holocaust assets, that the JNF itself was sitting on top of Holocaust assets. And an attempt was made, in fact, in April of 1998, the JNF published a list of 1,836 names, that it was willing to give back legal ownership of that property to the heirs of those Holocaust victims, which demonstrates that it is possible in Israel to give back legal ownership of landed real estate even decades later. Of course, in that instance, it was a Jewish agency releasing land back to fellow Jews and not to Arabs. So the question of what the scholar Oren Yiftachel has described, the ethnocracy in Israel, of course, factors into all this too, both into questions of compensation and restitution. Suffice to say that the issue of compensating the refugees has been a very important factor of any proposed peace deal that's been discussed since the 1990s going forward. Compensation involves property, but it surely is going to have to involve other things as well, because many refugees, as I said, didn't own property. the fate of this property, what happened, what Israeli institutions, settlements, individuals have benefited from this property, which again represented a massive windfall worth at least 800 million US dollars, 1948 dollars, was surely a factor in stabilizing the brand new state of Israel, assisting its economy greatly. And as I said, the question of refugee property continues to surface whenever discussions about a peaceful solution that will benefit all parties in the conflict are mentioned. I've probably talked too much and in too great a detail, so I'd like to end it there and pass the podium back to Kholoud, and we'll look forward to hearing what you folks have to say. Thanks very much.
Thank you very much, Michael. And of course, I'm personally interested in the topic because my family was displaced in 1948, and our land has never been compensated, or the family has never gotten restitution, same as the millions of Palestinian refugees everywhere. I wonder, and this is also a question that Annie from the audience has put, I wonder about how you trail the records in the archives between the sale of land under by the JNF, and if you have come across the parts that are specifically related to the JNF UK, because that is like, our audience would be interested to know more if something is related to the JNF UK and what is now called the British Park after the JNF UK in Israel.
Right. Well, there's many parts to that question. As I mentioned in my talk in 1954, the JNF, which was still in 1954 a British registered company, transferred all of its assets inside Israel, its assets and its liability, to the new JNF, or Keren Kayemet Israel, which was formed in Israel. Thereafter, my own personal research, I don't know what happened to other assets. The JNF, for instance, prior to 1948, controlled land in Syria, in southern Lebanon, and those are still owned by. Well, there's a long story I've investigated in another book about that. It's not also clear to me from my own research, which just focused on these particular questions, what the relationship between what is today known as JNF UK is and the original JNF that was registered in Britain in 1907. I haven't investigated to what extent those are still the same entity or whether there's a new post-1954 entity in Britain. But from the Israeli side, it's very difficult to get into, JNF land records, Israel Land Authority records. Lawyers I know in Israel have managed to trace, an individual's property was confiscated by the custodian, sold to the development authority, sold to the Jewish National Fund, and talk about even different registration numbers that were assigned to the new property. So it's a challenge, in other words, to actually get a paper trail to get into JNF records, to get into custodian absentee property records. I've known people who have done it in various ways, but as far as determining who owned the land on which certain parks sit, there are other ways to do that through the use of maps. I mean, the Ccp land records, for instance, which themselves are based on British records and the old British land numbering system. One could determine, I was part of a project that determined when the US Embassy was thinking of building an embassy in Jerusalem in the 1990s. I was part of a project that through maps determined today those boundaries that you're talking about used to be owned by this, and this refugee person. So there are ways to do it that way without even resort to the JNF record. So I hope that's a somewhat satisfactory answer to that question.
Thank you, Michael. I know you are not a legal person, but a historian, but something that comes to mind to me is the whole sale issue between the Israeli government and the JNF, and the issue of how legal was it? Because according, like the newly established state back at the time had regulations about the like absentee land, for example, and that, for example, abandoned land had to be abandoned for 5 years before it became state property. And from my understanding is that the sale between the JNF and Israel, the Israeli government, happened before that period passed. What what do you think about that?
You may be referring to laws which the British had based on the Ottomans about something called if you owned needy land, which was most of the land in Palestine, and you left it, you didn't cultivate it, you didn't do anything with it for a certain period of time, that the state could declare it what they called mahlul and take back the usufructure, because technically in the Ottoman Empire and in Britain and in British Palestine, you didn't actually own the land, you owned the perpetual right to use the land. But the state technically owned the, but that wasn't the operating issue. What the Israeli legislation did is it defined an absentee as someone who was not in his or her habitual place of residence on a certain date, and specified that date after, 29 November 1947. The definition was even such that someone who just went to the next town to go shopping and returned could be declared an absentee, even if that act occurred before Israeli forces controlled that area. So the operative legal, again, one can argue, the justice of it is a whole different question, but the operative legal term was an absentee who basically left their home, crossed into an Arab-controlled area, was a foreign Arab citizen. Even Jews were technically, some of them declared absentees, but their property was a whole different question. But the legal mechanism defined a person as opposed to a piece of land, and any property that person owned in any form, from a bank account on down, could be seized by virtue of the fact of them having absented themselves. So the confiscation laws were based on a different logic than the logic that you're referring to.
Referring to that again, I wonder also about, and you mentioned this in your book, about how Israel and the JNF also benefited from the lands that they took control over. Because like a big claim and propaganda that is made is that this land was just left, and it was like a land that was abandoned, and there was no way that the state could benefit from it. But in the book, you mention different ways that actually the land was used by the state.
Oh, yes. I mean, there were categories for which the government said it would not pay compensation. That is, only land that was individually owned by a person, not by corporations, not by a village as a communal entity, and not so-called wastelands. But for instance, in the case of stone quarries, the state, took them over and benefited from, mining rock and selling it. There was even one instance where land that nobody was cultivating that grew cactus, they collected the cactus blooms, sabah, and sold it to an Israeli company that used it for the production of industrial alcohol. So again, money was made on land that was considered worthless in terms of not compensating Palestinians. But certainly the JNF used this land for a variety of purposes. I mentioned there were 2 sales of about 1 million dunams each. I do have some statistics for the second 1 million dunams. Probably around half of it went for building new Jewish settlements. A large amount went for expanding existing Jewish settlements. A much smaller amount, maybe 160,000 dunams, to build forests, and some for housing in cities. So it used it for a variety of purposes, but mostly for building or expanding existing Jewish settlements. So that's a variety of information to respond to your question.
Michael, despite the different global entities that have, including the UN and the UN, the different organizations from the UN that supported the question of restitution and the right of return and so on, and it has been talked about for over 70 years now. The question itself is still on the table, and the failure of the global community to show serious efforts about the right of return and about restitution. What does that say, and why, in your opinion, is that still an issue that has failed, or the global community has failed to address until today?
I think the real reason is that the UN, once the armistice agreements were signed, the UN created the office of a mediator in 1948 to try to mediate the dispute. That was the Swedish diplomat Folke Bernadotte. After his murder by a Jewish group called Lehi, or Stern Gang, in September 1948, he was replaced by an American diplomat named Ralph Bunche. Bunche's purpose was to bring about ceasefire or armistice agreements between the two parties. But the UNCCP, the group that carried out the estimate of refugee property, its mission early on, starting in late 1948, was to try to make a permanent settlement, a conciliation, or the Arabic translation, tawfiq, between and among the parties. And the UNCCP brought together the Israel and Arab parties, mostly Arab states, at a conference in Lausanne, Switzerland, another one in Paris, and by late 1951, conceded that it had failed. The CCP still exists on paper, and it went on to do other things, such as these what it called technical matters, like determining the value and the scope of the refugee land. But I think the reason why the CCP failed, the UNCCP, or why everyone failed to address early on the question of return, compensation, is really two factors. Number one, the Israeli government, as early as 1949, said it would not entertain any proposals to compensate refugees separate from an overall peace agreement with the Arab states. For their part, the Arab states had been pressing, particularly the Arab states and some organizations that represented wealthy Palestinian landowners, particularly who owned orange groves, to get compensation now separate from a wider peace treaty. And so it ground to a halt from the beginning. I think a second factor, though, is that the UNCCP as a body is made up of 3 member states. And again, it still technically exists: the United States, France, and Turkey. So the 3 members are states, not 3 individuals, 3 states. And clearly, given the post-World War II balance of power, the United States was the senior member of those 3. And very early on, the United States agreed that the ultimate fate of the refugees was going to be resettlement in the Arab world. That the United States agreed with Israel that for whatever purpose, whatever reason, the American logic, that the refugees really were not going to go home in large numbers. The solution was resettlement in the Arab world, in places like the Jazeera region of Syria, in Iraq, and that compensation payments would be part of the mechanism for resettling and giving the refugees new lives. Essentially, the Americans conceded to the Israeli logic that the refugees really are not going to ever go home. And so from the beginning, literally within 3 years of 1948, the CCP's vision of what was possible in terms of return or compensation was immediately really solidified and set in concrete, that the basic formula would be the refugees will not go home, they will be resettled, that compensation and other financial inducements from Israel and the world community would go toward the process of building new lives for refugees in the Arab world. And I think that's the major stumbling block, is that early on, the UN, the United States, and Israel essentially saw things in the same way. And so that any further, at least UN diplomatic efforts at compensation outside of a peace treaty or return outside of a peace treaty were really frozen. And of course, in the decades since, the United States position has just hardened. And that's where we find ourselves really today.
We have a question from the audience about the implications of various legal rulings that are happening in the past few years about property that was owned by people and then resold, but then the original owners were not. So the very first sale was illegal. So for example, there is the 2017 Pissarro painting ruling in the French High Court that insisted that the privileged property remains the property of the original owners despite the passage of time and the subsequent buyers of the property. What do you think about these kinds of ruling, and what implications might they have on the Palestinian example?
I personally think they are of significance. And I have even other examples of that. For instance, in 1994, the same American government passed something called the Helms Burton Act, which empowers the United States government to sanction any company or person that uses property in Cuba that is or was owned by an American citizen and nationalized by the revolutionary government in 1959 or thereafter. So if a Canadian company builds a resort in Cuba along Veradero Beach that the United States government, according to that law, determined had been expropriated by the government of Fidel Castro, that even though the Canadian government says, well, we're just leasing it from the Cuban government, that they could still be sanctioned on the basis that, no, that is actually, you are using property that was seized from an American. I know there have been court cases in the European Union about, there's quite a market among Russians and others in acquiring real estate in the Turkish Republic of Northern Cyprus that was originally owned by Greek Cypriots who now live in the Republic of Cyprus. And of course, the EU understands the entire island to be legitimately under the government of Cyprus and thus subject to EU regulations. And there have been court cases brought against individuals, including Europeans, who are acquiring property that originally had belonged to Greeks but had been seized by Turkish Cypriot authorities after 1974. So there are a number of cases involving everything from art to real estate that have been enacted or pursued by courts, like I said, everywhere from the United States to Europe that do privilege the original ownership of property and regard subsequent acts of plunder or confiscation as not legally binding. I might add that there have been various efforts over the decades that Israeli authorities have and JNF authorities have carried on secret deals with Palestinian refugees in various parts of the world, including in Cyprus, paying people, refugees, for their abandoned property because that will do away with any such claims in the future. See, we actually paid you for it. So, but yeah, I personally think those laws hold a lot of promise. There are many organizations I mentioned before, even American diplomatic property in Jerusalem, that people have traced its ownership back to Palestinians and raised at least the moral claim that how can you do this? So yeah, I think there's promise there. The question is, in the end, is there enough power to convince both Israel and certainly its American patron that these issues should be taken seriously?
speaking of convincing, this is a question asked by Paul. How did Israel convince the wider legislators or the international community as well about what it was doing at the time was legal?
Well, I think the basis for that, and of course, this was rejected by certainly Arab states and Palestinians. In fact, there was a call in the 1960s for the United Nations to establish what it called a property custodian to formally be empowered to look after the refugee property. But Israel essentially has followed the logic and convinced the rest of the world of the logic of the modern nation state. You know, for better or for worse, nation states, they exist within certain boundaries, although in the case of Israel, that's a whole other question. They have flags, they have parliaments, they have seats in the United Nations, and within their territory, that they have sole legal power to do this, that, or what have you. And so for Israel, it was just a question of, you know, we are a state as of 14 May 1948. We passed laws just like any other country. We expropriate property for various purposes, to build a road, for public purposes, or in this case, to land that was no longer, you know, people weren't there anymore. We took it over. By and large, I think the world community then and even now has recognized that, yes, states have the ability to enact laws within their territory, even if other states might consider them discriminatory or what have you. I myself am living in a country where one of the two major political parties is trying to pass laws now to make it more difficult for people to vote. Coincidentally, they happen to be people of color. And the argument is, well, the state can legislate matters regarding elections. So really, I think that the very modern world obsession with the idea of a nation state and its sovereignty and authority is really at the heart of answering that question.
Back to the question of the JNF, and we know that the JNF was established before 1948, and it tried to buy land property before 1948 as well. To your knowledge, did the JNF own property before 1948 that was outside what became Israel or outside the Green Line? If so, what happened to that land after the occupation?
Yes, the JNF owned land in what became the West Bank and Gaza, and those particular properties were taken over in the case of Jordan by something called the Custodian for Enemy Property, which was a body that went back to British legislation enacted in Jordan during the Second World War, dealing with property owned by Axis powers. So to this very hour, there is in the Ministry of the Interior in Jordan an office called the Guardian of Enemy Property that has legal authority over some land that is now within Jordan. As for the West Bank land, of course, that was then transferred after Israel occupied the West Bank. Any pre-48 Jewish land in the West Bank that had been controlled by the Jordanian Guardian was passed over to various Israeli state authorities, and ditto in Gaza. The JNF also did own some land in other areas. So did the Palestine Land Development Corporation, which sold some of its land to the JNF. I'm talking about land near Khiam in southern Lebanon, lands in Hauran and Golan in what is Syria. But the most relevant, again, is Jewish land in places like Hebron that had been owned and then came under control of the Jordanian authorities. The Israeli logic was after 1967 not to give it back to the original Jewish owners, but that the Jordanian government offices control of the property would go over to an Israeli government office's control. Now, in the case of Hebron, it did allow Jews to move into some of those areas. But by and large, it did not restitute it back to the original Jewish owners, which is a whole fascinating question in and of itself. This also became true in the reverse. when Israel controlled East Jerusalem, and now these people could, in theory, now get their land back in West Jerusalem, refugees who lived in East Jerusalem, that wasn't allowed. So, but anyway, that's again another long answer to your question.
Yes, we have also another question about the different terminology about the issue of compensation and restitution. There's a question from Joseph. It says the legal definition of repatriation uh, encompasses 7 elements: restitution, return, rehabilitation of all kinds, resettlement, compensation for values not subject to restitution, guarantees for non-repetition, and the victim's satisfaction. Has anyone been as ambitious as to try quantifying that fuller compensation or fuller composite of the patriation due?
There have been some studies by various groups over the years about actually fairly detailed mechanisms for how you would go about formulating a, let's call it a compensation regime, whether it's associated with return or not. The International Office for Migration, Chatham House in London has been part of these various discussions where people have tried to come up with both mechanisms and possibly even amounts of money involved. I think, and I've been involved in some of those efforts, I think they're quite informative. People have laid out in detail bases on how you would establish some sort of both a fund for receiving money, whether Israeli compensation money, foreign donations, as well as some kind of office that would carry out the process of determining who received compensation. But it's really quite speculative at this point because, as the question you mentioned, there's beyond property compensation. There are issues of payments, sort of what the UN used to call ex gratia payments for refugeehood, loss of livelihood, mental suffering, wider things that you might categorize as reparations, a reparations regime. And it's difficult to quantify those. Others have also said, well, in terms of the value of the land, are you talking compensating it for the value of the land in 1948? Are you going to add interest over the rising land values in Israel? Let's say the UNCCP figure of $823 million. That's 1948 dollars. You're going to add interest to that. So really the devil is in the methodology. What would a compensation regime entail, and how are you going to determine that? And so there have been all sorts of figures floated.
There's also the question of like, how did the Palestinian refugee property and the right of return materialize within different peace processes? And I know it's a long history, but can you give a brief about how the issue was discussed, say, for example, in Oslo and Taba, for example, and the negotiations that took place in Camp David after?
Yes, at Camp David in 2000, the PLO negotiators, the Israeli negotiators, and U.S. President Bill Clinton essentially agreed that there would be some sort of fund set up, an international fund. It would be the fund's responsibility to end up paying people. And Israeli negotiators for a long time have wanted to include as potential beneficiaries of an international fund Jews who lost property, let's say in Iraq, in Egypt, in Syria, who ended up moving to Israel. That's a whole other question. But I think for better or for worse, and I'm sure your viewers know that there were many Palestinians that criticized actually Oslo in general, but the specific question of compensation. But the idea was essentially agreed upon that there would be some, and subsequent talks at FABA that you mentioned in late 2000, that there would be some sort of international fund that would entertain claims. And any Israeli payments, American payments, World Bank, whatever, would flow into this fund. And it would be the fund's responsibility to decide who gets what and what would be the basis of making that decision. Of course, that frees up certainly Israel or the PLO from having to track down individual persons. But they did get to that level of understanding. And some of in the 2000s, as I mentioned, some of the proposals that various non-governmental organizations proposed on how you would actually implement such a deal were themselves based around this idea that this was essentially going to be an international fund. It would not be the UN by itself. It would not necessarily certainly be Israel or the PLO that would be doing the hard lifting, the heavy lifting of making these decisions and assigning amounts. So the last substantive peace talks, which, Camp David and FABA, all sides had essentially agreed on some kind of an international fund formula for how this would be carried out.
Speaking of who would pay the money if that compensation has to take place, obviously the JNF wouldn't be one of those, because it now claims ownership of the lands that it has taken control over in historic Palestine. But the JNF itself still exists in many countries around the world, and it's still raising funds today. Why do you think that is, and what purposes do these funds that the JNF raises, what purpose do they serve?
Following the sale to the JNF of property, historically, most of the JNF's fundraising and fund distributions, at least the stated expenditures of funds, have been for things like afforestation, building forests, nature things. In other words, dealing with the land that the JNF already owned. And the state of Israel is probably the most subsidized state in human history in terms of foreign aid, development inside Israel, which is often done by the JNF, by the Jewish agency, which then doesn't come out of the state's own coffers, which can then be used state money for support, military equipment and so forth. So they've been doing a lot of forest building. I will add, and I've actually spoken with some people before with the Stop the JNF organization, that the JNF does have a subsidiary corporation called Hemnuta. Hemnuta is involved still with acquiring land and has been involved in some shady and actually scandalous. It's involved not only a corruption from officials in Hemnuta, but these slippery land deals by which land inside the occupied territories in East Jerusalem is being acquired and distributed. See, the JNF, once it owns land, can never sell that land to anybody, Jewish or non-Jew. They can lease it, but not. Hemnuta, as a subsidiary, does have the legal ability to sell land. So it can buy and sell, it can trade, even with Palestinians. But in the 90s going forward, there have been a number of cases in the Israeli press about Hemnuta acquiring Palestinian property, particularly in East Jerusalem, under various dubious legal means, and then transferring it to state agencies, which in turn transfer it to settler organizations like al-Ajarma and things like that. So I will add that where Hemnuta gets all of its money, I'm not clear. I haven't done research in that regard. So formally, JNF says most of our money now goes to building forests and places where you can picnic. But where does Hemnuta get its money to do the things it's doing inside the occupied territories is another issue.
Thank you very much. I would like to ask a final question because our time is coming to an end soon. What do you think that Palestinians who are still attempting and wanting the right of return or to regain ownership over their lands that were taken in 1948 or the years after, what options do they have today? And what of these options can be worthwhile pursuing?
Mhm. Um, the, the Israeli courts, I'm not sure, are effective. Um, the International Criminal Court has recently started. It said it was going to start an investigation about war crimes, but that's in the occupied territories. Um, I think, and I'm not speaking as an advocate, I'm just speaking as someone who's researched the issue. It seems over history that building up international opinion, and this is where the work of Palestinian organizations like Badil or the Right of Return Coalition or al-Aouda Coalition, um, uh, international solidarity, um, has worked the most to raise the issue of the refugees, that the Arab-Israeli conflict is not just Israel and Arab states. Israel can set up an embassy in Dubai and Abu Dhabi, and that's not going to solve anything as far as the Palestinian, which is the essence of the conflict. Um, yeah, I haven't seen many successful efforts either inside the United States in particular or pressuring the UN. The UN, as like I said, essentially gave up authority over these kinds of issues way back in the early 1960s. I'm sorry, 1950s. Um, I think that global public opinion seems to be the place that has proven the most effective for Palestinian refugees and their allies in raising issues of fairness, of restitution, of return, any combination of those issues. Um, it seems like that's been the most successful. I mean, people having conversations like this 30 years ago was much different. And 30 years prior to that was even much harder. And the difference has not been that governments have changed their minds or that the UN has become more receptive to Palestinian concerns. It's been global public opinion. And I know that may not sound satisfactory for people who say, yeah, but we need justice and we need it now. In fact, we needed it about 77 years ago. Uh, but really, I think that's from looking at the history of this issue, what has made the most difference is global public opinion, because that's a strange thing about history. Things just change suddenly, instantly. There's just ground building, and suddenly everything changes in ways that even baffle historians and social scientists. And so that, to me, I think would be has been the most fruitful effort made by refugees, refugee organizations, and their supporters around the world.
Thank you very much, Michael. I would like to leave the floor again to you if you would like to have any final message or remark for our audience today.
Mm-hmm. I don't. I don't really. I think the audience probably is familiar with these issues very much, but I will say that I will end with one thing that in my more recent research about how the issue of Israel-Palestine factored into American public attitudes in the 1960s and the 1970s. I just published 2 books about certainly how Black Americans viewed the issue and how it was quite a divisive issue among American Blacks, as well as how where one stood on the Arab-Israeli conflict really served to divide left-wing Americans, white Americans, in the 60s and 70s, and still does. And I'm reminded that a famous American socialist, democratic socialist named Michael Harrington, in an offhand comment he wrote in a book in the early 70s about the history of socialism, he said, Israel is perhaps the last country that has been created by the Western world. Now, he himself was quite sympathetic to Israel, and I don't think he meant it quite in the way that it came out. But the fact that a history of Western societies expanding out into the rest of the world, starting, as we know, in 1492 and thereafter, creating new countries in territories that were inhabited by other people. The presumption that Europeans in particular had a right to do this, to create settler societies, whether the United States or Australia or New Zealand or the southern parts of Africa or Palestine. I mean, the early Zionist movement were Europeans. I think frames this entire discussion. And as an historian, I always encourage people to remember that. The Palestinian American historian Rashid Khalid has just written a book about this, that to really understand the Arab-Israeli conflict, the struggle among Palestinian and Zionist Jews, one has to consider the wider imperial settler context here. And the idea of replacing people, bringing in new settlers, acquiring land, cultural property, even names and foods of the indigenous people has a long track record. And I think the more the world understands the settler colonial nature of global imperialism, of racism, I think it helps people frame the issue more broadly. It's not just a question of, well, legal property rights. It's a much wider process at work here. And that would be the last word I would leave to your audience. And I certainly thank the audience for its rapt attention.
Thank you, Michael, very much for being with us today, and thank you for the audience. I join my voice to yours about the importance of understanding not only the smaller issues, but also the bigger historical narratives around Indigenous people, not only in Palestine, but everywhere, can help us in understanding more about colonial history and how it developed. Thank you very much again, Michael. And I would like to finish by reminding our audience that our upcoming webinar will be on the 20th of March, and there's music coming from my window, so apologies about that. And the guest will be Richard Falk next time. So thank you very much. Thank you, Michael, and have a nice rest of day. And thank you for everyone who joined us today. Have a nice evening. Bye-bye.